Good morning. This is Jeremy Tipton from Springs Law Group presenting another Monday Moment. Again, my name is Jeremy Tipton. I am a litigation associate here at Springs Law Group, and I wanted to take a moment this morning to talk to you about personal injury litigation and what a personal injury case looks like when it's in the litigation phase at our office. And so when I use the term litigation, I'm referring to a case that has been filed as a lawsuit in either county court or district court in El Paso County, Colorado. So really, in my mind, a litigation case has 5 main stages. Those stages are: number 1, complaint and answer; number 2, written discovery; number 3, depositions; number 4, mediation; and then ultimately number 5 is a jury trial. So let's break that out and let's talk about what each of the 5 categories mean and what you can expect if your case is now in the litigation phase at our office. So number 1 is the complaint and answer. So how the case starts in litigation is our office, as the plaintiff means the party giving rise or starting the litigation, files a complaint. And the complaint lays out to the court the facts as we believe them and the allegations against the defendant, which would be the driver of the other vehicle. And so it'll say things like what time of day the accident happened, where the accident occurred, who was the driver of the vehicle, if the driver of the vehicle was wearing their seatbelt, and really kind of details all the nuances of the accident. So we'll file that with the court, as well as our claims in which we believe we're entitled to compensation for. And we'll file that. A copy of that complaint will be served on the other driver by a process server. Once they have received service, we'll file with the court notice of service, and then the lawsuit begins at that point. After the defendant, so the driver of the other vehicle, receives a copy of that complaint, most of the time what they'll do is they'll notify their insurance company. We will also send the other driver's insurance company a copy of the complaint. They will be appointed, or they will appoint an attorney either through an outside firm or through their own legal department to defend the other driver in the lawsuit. After speaking to the other driver, that attorney will draft what's called an answer. And the answer outlays their defenses to our claims that we've outlined in our complaint, showing us as the plaintiffs how they plan on defending the lawsuit if it ultimately does go to jury trial all the way to step 5. And so that's the first step. We file a complaint, then the defendant, the other driver, files their answer. After we get through the first step, we then go into the second step, which is written discovery. Written discovery is when attorneys on both sides, plaintiff and defendant, create a set of questions referred to as interrogatories that both sides have to answer. Those questions will be a variety of things, such as, again, how did the accident happen? Where did it occur? Were there any other individuals involved except the named plaintiff and the named defendant? They'll ask about both drivers' driving histories. They'll ask about medical treatment and if there are any prior injuries that either side should know about. They will also include things such as requests for production. Requests for productions are documents that either side may find useful as we move forward with the claim, such as medical bills from the plaintiff, medical records from the plaintiff. The plaintiff may request things of the defendant, such as their driving record, their cell phone, data usage and history on the date of the offense to see if the other driver was maybe improperly using their cell phone while they were operating the vehicle. There will also, included in those written discovery requests will also be requests for admissions, which are questions from either party asking the other party to admit or deny certain things. For example, admit you were the cause of the accident. Those will be sent to both sides. Each side has 35 days to respond to those. And then again, the attorney will review all of those written discovery requests, the interrogatories, the request for productions, the request for admissions with our clients, and formulate responses to those. Those do have to be signed by the individual plaintiff and the defendant in the state of Colorado under oath, just to certify and confirm the other party is telling the truth and they're bound by oath to do so. Once those get filed, that encompasses the written discovery portion of the lawsuit. And then we move into step 3, which is depositions. The deposition phase is where the opposing attorney gets to ask the opposing party questions. Right now, this is being conducted via Zoom. Normally, this is something that would happen in person, usually in a conference room at an attorney's office. But right now, it is taking place over Zoom, just like I'm talking to you now virtually. And the other party will have an opportunity to, again, ask questions related to things similar in the written discovery. And while this may seem a little redundant, since the questions will be pretty similar to what's contained in the written discovery, the thought process is, and the reason that it's important is to show consistency in answers as the lawsuit progresses, because that adds credibility to what the other individual is saying. And so that's kind of the purpose for depositions, is to confirm and hopefully create more consistency with the responses in written discovery. And again, as I said, both attorneys will have the opportunity to ask opposing parties questions. The attorney can also ask their own client questions if there are certain things that need to be clarified or they believe will or what weren't covered by the other attorney's questions. And so that's depositions. And then after depositions, we move into the 4th stage, which is mediation. Mediation is conducted by a third party that's neutral. So not somebody that's chosen solely by the plaintiff, not somebody that's chosen solely by the defendant. It's a neutral third party who will conduct what's called a shuttle mediation. And so how a shuttle mediation works is the mediator goes between the two rooms, one room with the plaintiff, one room with the defendant, and talks about strengths and weaknesses of the case, as well as settlement values. And so how this is working right now with the world in the pandemic still is this is also conducted over Zoom. The mediator will be in the main Zoom room. There will be 2 breakout rooms in Zoom where the plaintiff will be in one room, the defendant and counsel will be in another room. Neither of the parties communicate directly during the mediation. All the communication is done through the third party mediator. And just like if we weren't in COVID, the mediator goes back and forth between the 2 rooms. Right now it's the virtual rooms in Zoom. And again, presents the strengths of the opposing party's case, the weaknesses of the opposing party's case, and then the parties will make, if you're plaintiff, you will be making what we call a demand from the insurance company. The insurance company will then respond with an offer, and the 2 parties go back and forth until one of 2 things. One, the parties come to an agreement, which is great, and that means the case is going to settle, or the parties are just so far apart at a certain point the mediation will end and the case will just proceed to trial. But just like in the criminal justice system, most of these civil litigation cases do settle and they end at this mediation stage. But again, if they don't, the case will proceed to trial. And that brings us to our last step, which is trial. Trial is conducted in front of a jury of 12 individuals if it is in district court. It is a jury of your peers, similar to how it would be in a criminal trial setting. And so the trial kind of operates similarly to that. If you've ever seen a criminal trial with the juries conducting voir dire at the beginning to select the jurors, conduct opening statements, presenting their opening arguments to the jury. After that, both sides will put on testimony, then closing arguments, and the jury will ultimately reach a verdict. And hopefully within the coming weeks, I will do a supplemental video on each topic, just kind of expanding, talking about all of them in more detail. I just wanted to provide an overview this morning. And so that's really a quick overview of what a case looks like as it's going through litigation. You have the 5 main stages. As I said, most of the cases will settle after mediation, but if it doesn't, we're prepared and ready to take them to trial if needed. So that's what a case looks like if it is in the litigation phase at our office. If you have any questions about anything contained in this video, please give us a call. You can see that our telephone number is on the video. You can also comment on this video, and one of the attorneys in the office will be thankful to reach out to you. All right, have a great Monday. Look forward to seeing you all soon. Thanks.